Part 74 of the Chronicles of Crime, Volume 1, by Camden Pelham. This LibriVox recording is in the public domain. Part 74. John Bellingham, executed for the murder of the Right Honourable Spencer Perceval. Part 1. On the 11th of May in the year 1812, an event occurred which excited universal dismay and regret in the minds of the whole of the British public: the death of the Right Honourable Spencer Perceval, then Chancellor of the Exchequer, by the hand of an assassin. John Bellingham, the author of this crime, was brought up in a counting house in London, and afterwards went to Archangel, where he lived during a period of 3 years in the service of a Russian merchant. Having returned to England, he was married to a Miss Neville, the daughter of a respectable merchant and shipbroker, who at that time resided at Newry, but who subsequently removed to Dublin. Bellingham, being a person of active habits and of considerable intelligence, was subsequently employed by some merchants in the Russian trade, by whom he was induced again to visit Archangel, and he in consequence proceeded thither, accompanied by his wife, in the year 1804. His principal dealings were with the firm of Dorbecker and Co., but before 12 months had expired, a misunderstanding arose between them, and each party made pecuniary claims upon the other. The subject was referred by the Governor General to the decision of 4 merchants, 2 of whom Bellingham was allowed to select from his countrymen resident on the spot, and by the award of these arbitrators Bellingham was found to be indebted to the house of Dorbecker and Co. in the sum of 2,000 roubles, but this sum he refused to pay, and appealed to the Senate against the decision. In the meantime a criminal suit had been instituted against him by the owners of a Russian ship which had been lost in the White Sea. They accused him of having written an anonymous letter to the underwriters in London, stating that the insurances of that ship were fraudulent transactions, in consequence of which the payment for her loss was resisted. No satisfactory proof being adduced, Bellingham was acquitted, but before the termination of the suit he attempted to quit Archangel, and being stopped by the police, whom he resisted, he was taken to prison, but was soon after liberated through the influence of the British consul, Sir Stephen Shairp, to whom he made an application, requesting to be protected from what he considered the injustice of the Russian authorities. Soon after this the Senate confirmed the award of the arbitrators, and Bellingham was delivered over to the College of Commerce, a tribunal established and acknowledged by treaty for taking cognizance of commercial matters relating to British subjects. He was to remain in custody till he discharged the debt of the 2,000 roubles, but his confinement was by no means severe, for he had permission to walk wherever he pleased, attended by an officer belonging to the college. Lord Granville Leveson Gower being at this time ambassador at the Russian court, Bellingham made frequent application, and at various times received from his secretary small sums of money to support him during his confinement. One night in particular he rushed into his lordship's house at St. Petersburg, and requested permission to remain all night, to avoid being secured by the police, whom he had escaped. This was granted, although Lord Gower had no authority to protect him from a legal arrest, but it appears he was afterwards retaken, and being confined by the authorities of the country, the British ambassador could have no pretence to solicit his release. His lordship, however, in a conversation with the Minister for Foreign Affairs, expressed a personal wish that the Russian government, seeing no prospect of recovering the money from Bellingham, would liberate him on condition of his immediately returning to England, but we are not told what effect was produced, as Lord Gower soon after quitted the Russian court. The foregoing is taken from the statement published by Lord Granville Leveson Gower in his own justification against the charge made against him by Bellingham on his trial, and we hope for the honour of our country that it is correct, and we must confess that a review of all the circumstances tends to confirm its accuracy. Our ambassador, it is admitted, had the case investigated, and as his refusal to interfere was subsequently confirmed by that of the English government, it is evident that Bellingham could have had no just cause of complaint, or at least none of a nature to call for diplomatic negotiation or pecuniary recompense. In justice to the unfortunate man, we shall, when we come to his trial, give his own statement, and leave the reader to draw his own conclusion. Bellingham, having by some means or other procured his liberation, in the year 1809 returned to England, and at Liverpool commenced the business of an insurance broker. It appears, however, that from a constant recital of the circumstances which had occurred in Russia, his complaints were aggravated in his own mind into grievances, and he at length began to talk of demanding redress from the government for what he termed and appeared to consider the culpable misconduct of their officer, Lord Gower, and his secretary, in omitting to defend his rights as a British subject, and he eventually wrote to the Marquis Wellesley, setting forth the nature of his case, and the grounds upon which he expected that some compensation would be made. By the noble Marquis he was referred to the Privy Council, and by that body to the Treasury, but his efforts being unattended with success in either quarter, he determined to proceed to the Chancellor of the Exchequer, Mr. Perceval, with a view to obtain his sanction and support for his demand. Mr. Perceval, however, having made himself master of the case submitted to him, declined to interfere, and Mr. Bellingham was then advised by his friends that the only resource left to him was a petition to Parliament. As an inhabitant of Liverpool, he applied to General Gascoigne, then member for that city, to present a petition to the House of Commons; but that honourable gentleman having ascertained upon inquiry that the case was unsupported by the Chancellor of the Exchequer, he refused to have anything to do with it. Driven now to pursue a course quite unusual in such cases, he petitioned the Prince Regent, but from him he was referred again to the Treasury, and he again received an intimation that all applications from him must be futile. 3 years had now been spent in these constant and fruitless attacks upon the government, but the unfortunate and misguided gentleman appeared even yet to cherish hopes that his case would be attended to. On one occasion it is reported that he carried his wife, who had in vain striven to wean him from what she considered to be his malady, and another lady, to the Secretary of State's office for the purpose of showing them the success with which his exertions were attended; and although he then, as he had before, received a flat denial of his claims, yet he continued to assure them that he did not in the least doubt that ere long all his hopes would be made good, and he would receive compensation for his sufferings. He now adopted a new and certainly an unprecedented mode of attack. He wrote to the police magistrates of Bow Street in the following terms: To their worships the police magistrates of the public office in Bow Street. Sirs, I much regret its being my lot to have to apply to your worships under most peculiar and novel circumstances. For the particulars of the case, I refer to the enclosed letter of Mr. Secretary Ryder, the notification from Mr. Perceval, and my petition to Parliament, together with the printed papers herewith. The affair requires no further remark than that I consider his Majesty's Government to have completely endeavoured to close the door of justice in declining to have or even to permit my grievances to be brought before Parliament for redress, which privilege is the birthright of every individual. The purport of the present is therefore once more to solicit his Majesty's ministers through your medium to let what is right and proper be done in my instance, which is all I require. Should this reasonable request be finally denied, I shall then feel justified in executing justice myself, in which case I shall be ready to argue the merits of so reluctant a measure with his Majesty's Attorney General, wherever and whenever I may be called upon so to do, in the hopes of averting so abhorrent but compulsive an alternative. I have the honour to be, Sirs, your very humble and obedient servant, John Bellingham. No. 9, New Milman Street, March 23rd, 1812. This letter was at once conveyed to the members of the Government, but it was treated by them as a mere threat, and no further notice was taken of it, than on Mr. Bellingham's again presenting himself, by a fresh refusal being given to him by Mr. Reed. Once more he applied to the Treasury, and again he was told that he had nothing to expect, and according to his statement, Mr. Hill, whom he now saw, told him that he might resort to whatever measures he thought fit. This, he declared, he considered a carte blanche to take justice into his own hands, and he accordingly determined to take such measures of revenge as he madly supposed would effectually secure that attention and consideration for his case which he deemed it had not received, and to which it was in his opinion fully entitled. This unhappy determination being made, he began to make the necessary preparations for the foul deed which he contemplated. His first step was to make himself acquainted with the persons of those ministers who had seats in the House of Commons, and for this purpose he nightly visited the House, and there usually took his seat in the gallery appropriated to strangers, and having obtained a general knowledge of their persons, he afterwards posted himself in the lobby of the House, in order to be able to identify them. He then purchased a pair of pistols, with powder and ball, and had an additional pocket made in his coat for carrying them the more conveniently. On the evening of the 11th of May 1812, he took his station behind the folding doors leading into the body of the house, and at 5 o'clock, as Mr. Perceval advanced up the lobby, he presented one of his pistols and fired. His aim was true, and the ball entered the left breast of his victim and passed through his heart. Mr. Perceval reeled a short distance, and exclaiming "Murder!" in a low tone of voice, he fell to the ground. He was instantly picked up by Mr. Smith, the member for Norwich, and another gentleman, and carried into the office of the Speaker's secretary, where he expired almost immediately. Loud cries of "Shut the door! Let no one out!" were heard immediately after the shot was fired, and several persons exclaimed, "Where's the murderer?" Bellingham, who still held the pistol in his hand, answered, "I am the unfortunate man," and he was immediately seized and searched. Mr. V.G. Dowling was among the first who went up to him, and on his examining his person he found in his left hand trousers pocket a pistol loaded with ball and primed. There were also found upon him an opera glass, with which he had been accustomed to examine the persons of the members of the House while sitting in the gallery, and a number of papers. Upon his being interrogated as to his motives for committing such an act, he replied, "Want of redress and denial of justice." During the momentary confusion which followed the firing of the pistol, he made no attempt to escape, and though, when taken into custody, he betrayed some agitation, he soon recovered his self-possession, and with great calmness answered every question put to him. During his examination before the magistrates upstairs in the House of Commons, he still retained his self-possession, and even corrected a witness as to an omission in his evidence. He persisted in denying any personal enmity to Mr. Perceval, for whose death he expressed the greatest sorrow, separating, by a confusion of ideas, the man from the minister, and seemed to think he had not injured the individual, though he had taken away the life of the Chancellor of the Exchequer. This event excited the greatest sensation in the country. A cabinet council was called, and the mails were stopped until instructions were prepared to secure tranquillity in the districts; for at first it was apprehended that the assassin was instigated by political motives, and that he was connected with some treasonable association. Measures being provided for securing order through the country and the metropolis, Bellingham was removed under a strong military escort about 1 o'clock in the morning to Newgate, and conducted to a room adjoining the chapel. One of the head turnkeys and 2 other persons sat up with him all night. He retired to bed soon after his arrival at the gaol, but he was disturbed during the night, and he had no sound sleep. He rose soon after 7 o'clock, and requested some tea for breakfast, of which, however, he took but little. No private persons were admitted to see him, but he was visited in the course of the day by the sheriffs and some other public functionaries. He conversed very cheerfully with the sheriffs and others who were in his room, and expressed no regret for the deed which he had perpetrated, conceiving himself, as he stated, justified in what he had done, and that it now only remained for the laws of his country to determine the nature of his guilt, which he did not seem to view in a criminal light. He stated that the question would soon be tried, when it would be seen how far he was justified. He considered the whole as a private matter between him and the government, who gave him a carte blanche to do his worst, which he had done. Alderman Combe, as one of the committing magistrates, was very active in his endeavours to trace Bellingham's connections and habits, and for that purpose went to the house of a respectable woman, where he lodged in New Milman Street, but could learn from her nothing that indicated any conspiracy with others. His landlady represented him as a quiet, inoffensive man, though at times rather eccentric, which she instanced by observing that when he had lodged there only 3 weeks at 10 6 per week, she was surprised to find that he had given her servant maid half a guinea for herself. On being told the deed which he had perpetrated at 5 o'clock on Monday the 11th of May 1812, she said that it was impossible, for that she had met him a few minutes before that time, when he told her that he had just been to buy a prayer book. She represented him as of a religious turn of mind. In gaol the prisoner requested to have pen, ink, and paper to write some letters to his friends, and he accordingly wrote one to his family at Liverpool, which was delivered open to Mr. Newman. The following was sent to Mrs. Roberts, No. 9, New Milman Street, the lady at whose house he lodged. It will serve to show the state of his mind in the miserable situation to which he had reduced himself. Tuesday morning, Old Bailey. Dear Madam, yesterday midnight I was escorted to this neighbourhood by a noble troop of light horse, and delivered into the care of Mr. Newman, by Mr. Taylor, the magistrate and MP, as a state prisoner of the first class. For 8 years I have never found my mind so tranquil as since this melancholy but necessary catastrophe. As the merits or demerits of my peculiar case must be regularly unfolded in a criminal court of justice to ascertain the guilty party by a jury of my country, I have to request the favour of you to send me 3 or 4 shirts, some cravats, handkerchiefs, nightcaps, stockings, &c., out of my drawers, together with a comb, soap, toothbrush, with any other trifle that presents itself which you think I may have occasion for, and enclose them in my leather trunk, and the key please to send sealed per bearer, also my greatcoat, flannel gown, and black waistcoat, which will much oblige, Dear Madam, your very obedient servant, John Bellingham. To the above please add the prayer books. To Mrs. Roberts. Soon after 2 o'clock the wretched prisoner ate a hearty dinner, and requested that in future he might dine at about the same hour, and after passing the rest of the day in a tranquil manner, he retired to bed at 12 and slept until 7 the next morning, being attended by 2 persons during the night. He breakfasted at about 9 o'clock, and appeared perfectly composed, and on the sheriff's revisiting him, accompanied by several gentlemen, he was found to be unaltered in his demeanour. On his being spoken to on the subject of his trial, he conversed with apparent indifference, but on the melancholy fact of Mr. Perceval's murder being alluded to, he became less tranquil, persisted in vindicating the act, and said that when his trial came on before a jury of his countrymen, it would be for them to determine how far a minister of the Crown was justified in refusing justice to an injured individual, and he declared that if he had 1,000 lives to lose, he would have risked them in pursuit of justice in the same way. He spoke of the result of his trial with the utmost confidence, and on his being asked whether he had any commands to his wife at Liverpool, he declared that he had not, and that in a day or 2 he should join her in that city. On the 15th of May 1812, 4 days after the death of Mr. Perceval, the trial of the prisoner came on at the Old Bailey. The judges at 10 o'clock took their seats on each side of the Lord Mayor, and the Recorder, the Duke of Clarence, the Marquis Wellesley, and almost all the aldermen of the City of London occupied the bench. The court was crowded to excess, and no distinction of rank was observed, so that members of the House of Commons were forced to mingle with the throng. There were also present a great number of ladies, all led by the most intense curiosity to behold the assassin, and to hear what he might urge in defence or in palliation of his atrocious act. At length Bellingham appeared, and advanced to the bar with a firm step, and quite undismayed. He bowed to the court most respectfully and even gracefully, and it is impossible to describe the impression which his appearance, accompanied by this unexpected fortitude, produced. He was dressed in a light brown surtout coat and striped yellow waistcoat, his hair plainly dressed, and without powder. Before the prisoner was called on regularly to plead, Mr. Alley, his counsel, made application to have the trial postponed, for the purpose of procuring proofs of his client's insanity, which was alleged in 2 affidavits he held, and he said that he had no doubt, if time were allowed, that the prisoner could be proved to be insane. Mr. Alley was here interrupted by the court, who refused to hear him until the prisoner had first pleaded. When the indictment was read, the usual question, guilty or not guilty, was put to Bellingham, when he addressed the court: "My lords, before I can plead to this indictment, I must state, in justice to myself, that by hurrying on my trial I am placed in a most remarkable situation. It so happens that my prosecutors are actually the witnesses against me. All the documents on which alone I could rest my defence have been taken from me, and are now in possession of the Crown. It is only 2 days since I was told to prepare for my defence, and when I asked for my papers, I was told they could not be given up. It is therefore, my lords, rendered utterly impossible for me to go into my justification, and under the circumstances in which I find myself, a trial is absolutely useless. The papers are to be given to me after the trial, but how can that avail me for my defence? I am, therefore, not ready for my trial." The Attorney General was proceeding to explain to the court what had been done with reference to the prisoner's papers, when Chief Justice Mansfield interrupted him, observing it was necessary the prisoner should first plead. The prisoner was again interrogated, when he pleaded not guilty to both counts of the indictment. The Attorney General: "I will now answer what has fallen from the prisoner. He says that he has been denied access to his papers. It is true that government, for the purposes of justice, has retained them; but it is also true that he has been informed that if he asks for them at the time of his trial they should be ready, and any of them which he might think useful to his defence should be given to him, and in the meantime, if he considered it necessary, he might have copies of them. This we are ready to verify on oath." The Clerk of the Arraigns, Mr. Shelton, then read the indictment, which charged the prisoner in the usual way with the murder of the Right Honourable Spencer Perceval, with which he was also charged on the coroner's inquisition. Mr. Abbott having opened the case, the Attorney General addressed the jury. He said that a lamentable and painful task devolved upon him to state to the jury the circumstances of this horrid murder, a crime perpetrated on a man whose whole life he should have thought would have guarded and protected him against such an attack, who, he was sure, if enough of life had been left to him to see by whose hand he had fallen, would have spent his last moments in uttering a prayer for the forgiveness of his murderer. But it was not a time for him to dwell on the public loss which had been sustained. Its brightest ornament had been torn from the country, but the country had done justice to his memory. These were not considerations, however, by which they must be swayed. It was not revenge, nor was it resentment that ought to have any influence on their consideration of the question. They were to satisfy the public justice, to take care, by their verdict, that the public should not be exposed to such horrid crimes. With respect to the prisoner, he knew nothing, nor did he know how his life had been spent, except so far as related to the circumstances of this case. He had been in business, and had acted as a merchant, in the course of which he had shown himself a man of sound understanding in every act which he performed, and he had not only conducted his own affairs with understanding, but he had been selected by other persons to manage theirs. Having stated the main facts of the case as we have already detailed them, he entreated the jury to consider it not as the murder of so eminent a person, but as the murder of a common individual. To suppose the meanest subject to have suffered as Mr. Perceval had suffered, and to return their verdict as they would upon that case. Was he or was he not guilty? To that point they must direct their attentions, and he knew of no reason to cause even a doubt. But what remained? This only: the attempt which had been made that day to put off the trial of the prisoner on the ground of his being fit for this or any other crime, as he was afflicted with insanity. Let them consider this a little. The prisoner was a man conducting himself like others in all the ordinary circumstances of life, who carried on business, none of his family or friends interfering, no pretence being suggested that he was unable to superintend his own affairs. What clearer proofs then could be given to show, contrary to the defence set up, that he was not what the law called non compos mentis, that he was an accountable being? He knew the cases where the plea of insanity would be received, where, for instance, a murder was committed by a person whose mental infirmity might be considered as very nearly the absence of all mind. Against their defence there was no argument, but he was this day to learn whether the wickedness of the act which the prisoner was called on to answer was to be considered an excuse for its perpetration. Travelling through his whole life, what ground could they adduce for such a plea? His every act appeared rational, except one, and that was only irrational because it was so horrid that the imagination of man could not fancy to itself the existence of so atrocious a deed. But how far must this argument go? It must arrive at this conclusion, that every act of gross and unusual atrocity would carry its defence along with it, that every act of peculiar horror would have within itself a certain defence, for the barbarity of the deed would be considered as a proof that the mind which directed it was not in a state of sufficient security to judge whether the action was right or wrong, and if the mind possessed the power of forming that judgment, the prisoner was criminally accountable for the act. A man might be infirm in mind, insufficient to dispose of his property, or to judge of the claims of his respective relatives, and if he were in that situation, the management of his affairs might be taken from him and vested in trustees, but such a man was not discharged from criminal acts because he could not transact civil business. Many cases had occurred within his memory in courts of law, in which it was proved that a person in many respects had evinced symptoms of insanity up to a certain time, but the question then was, whether that insanity was of such a description as precluded or permitted the knowledge of right or wrong. In every one of the cases which recurred to his memory, though a certain degree of madness was proved, still, as the parties seemed to have sufficient sense to distinguish right from wrong at the time of the perpetration of the acts charged against them, they were held to be criminally accountable. Here there was no deficiency of understanding whatever. No opinion of others to that effect was adduced. On the contrary, he was entrusted with the management of his own and others' affairs. The question was, whether at the time the murder was perpetrated he possessed sufficient sense to distinguish between right and wrong. What conclusion could they draw in favour of the idea which had been suggested? Let them take from their recollection the frightful nature of the act with the commission of which he was charged. Let them take from it its accumulated horrors, and the prisoner stood before them in a state of sanity, and fully accountable for the act of which he thought little doubt could be entertained he had been guilty. The learned gentleman concluded by expressing his satisfaction at the fact that the prisoner stood alone on that occasion, that he was unconnected with, and unaided and uninfluenced by any other person or party in the country, and that this deed could not therefore be attributed to any but the personal feelings which he entertained towards his Majesty's government. On him, and on him only, did the disgrace which he had excited rest, and the character of the country was entirely free from any participation in it. End of Part 74.